And so the one in Texas is pretty
Chef's kiss.
good,
Except for what the Senate did.
except for what the Senate did to us. The House version was perfection.
It was like 6 pages.
It was perfect. That was Richard's whole life. And then we got to go sit in the speaker's office and like negotiate the floor amendments. It's awesome. We are the Arms Attorneys. Today we're talking about some essentially good changes in gun law coming down the pike. Stick around. We're going to talk about who's changing what, about why this is more and more of a red state trend, and finally, what you might be able to do about it to help your state. But before we get started, show your support for the Second Amendment by hitting the like button.
And this news is coming out of the state of Oklahoma. And I think there's some really awesome discussion to be had here and some themes we see in all of these states, especially states that have passed constitutional or permitless carry. All right, we've expanded or removed the infringements on who can carry. What are the new target-rich environments for these folks? And I'll say just generally, and I'm not talking about y'all. I mean, if you're watching this, you are super engaged. But I'll say there has been a general flavor of, hey, we won, and now we don't have to kind of do anything. And we saw that. I'm sure this happened with you. A bunch of local elections just happened all across the United States. Guess what? We got our Donald Trump elected president. Everybody's super energized, and then just kind of checks out like, hey, things are fine. We got to keep our foot on the gas. And I think this attack on expansion of self-defense rights, removing sensitive places, this is where the fight's going to be.
Oh, yeah. So, I mean, we've got in the last, oh my gosh, when did this trend start? Just before 2020, when all these states started rolling through to constitutional carry, and it was like one after another, like dominoes, and it felt
we had like
so
7
good.
in 1 year.
Yeah. And now, I mean, more than half the country is constitutional carry, which was unimaginable a decade ago.
Yeah.
Unimaginable when we all used to call it Vermont carry, because that's basically the only person who implemented it. State. But yes, so, I mean, that does, I think, produce this feeling. But the state of Oklahoma, like many states, I will say, including our great state of Texas, is trying to get us there as well.
Yeah.
Is moving the ball forward in small ways, in ways that are incredibly important, though. So 2 bills have passed, both the Oklahoma House and the Senate. As we film today, you'll see this video tomorrow, which is Wednesday. They are on the governor's desk. He has until Saturday to sign them. If he does not sign them, they become law anyway. I mean, hell, by Wednesday, he could have already signed them for all I know.
Yeah. I wonder how many states have a pocket veto, because that's the same thing in Texas. If the governor doesn't sign it, it passes into law.
Yeah, I don't know how many states do the opposite. How many have a pocket veto? That's interesting.
If your state has pocket veto, leave it in the comment section below. That'd be a fun little data point.
That would be a data point.
Yeah, so let's talk about this first one. This is 2818. This has to do with just revising, and this shows you how changing the simple definition from pistol to firearm can have a really, really big impact when it comes to self-defense.
Yeah, so this bill does a lot in terms of just your general self-defense privilege in the state of Oklahoma. First, we're talking about pointing a firearm in self-defense, and it changes the word pistol to the word firearm. Very, very important change. And also, we talk about in the Oklahoma law, well, you do this in self-defense, right? Self-defense being a very broad, encompassing term. We're explicitly adding this defensive premises, defensive property here, which is a very good thing, because if it's not explicit, it will get taken advantage of by the other side. And that's the problem.
Yeah, and I'll say, and I do this too, I use self-defense as shorthand for everything. I use it for defensive property, defensive
third parties,
defensive third person, and really when it comes to the law, we want it to be explicit. And you probably do the same thing. You say self-defense, even though you're talking about defense of a car burglary, right? So, I think it's good making it explicit. The other thing I want to talk about, which is kind of an interesting thing specifically with this bill, is it removes this except in self-defense, pointing, this is generally a crime under Oklahoma law. It kind of moves that down into another section saying this section doesn't apply, for all of these defensive situations. And it outlines them, and it's great. It's a huge expansion.
But Richard doesn't like it.
Well,
I get it. Go on.
Yeah, so whenever, and this is kind of a fun little tip. I mean, this is some insider information for y'all. Whenever we have a crime saying except as provided, what prosecutors have to prove is, hey, it wasn't self-defense, and they have to plead that it wasn't self-defense, and then they have to prove the crime, right? When you move this down to saying like, hey, this section doesn't apply to, that transforms it into an affirmative defense. And so the prosecutor doesn't have to have to plead that it wasn't self-defense and then prove it. This just says, here's our crime. And then if the defense raises the affirmative defense, well, obviously they have to disprove that beyond a reasonable doubt. But you just see a little mechanic moving that except from the main operative paragraph of the law down into the this doesn't apply. That has huge implications.
It does. Now, I think this is still, on the whole, very, very good.
Very
because
good,
it
very
does
good.
other things as well. And I know that sounds like very ticky-tacky, but imagine that it's a DWI case, and also called DUI in most of the country, I suppose. In Texas, it's DUI as opposed to a DWI. We have DWIs here. But so imagine, right? You're driving while intoxicated case, and there's a list of things the prosecution has to prove, right? It happened in this county on this day. You were operating a motor vehicle and you had a blood alcohol content of, or otherwise intoxicated. Great. Check, 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 check. But what we've done is taken potentially a world in which one of those check boxes for this kind of firearms case would have been
Self-defense.
not self-defense,
Yeah.
right? Prosecutor would have to check that box, put it in their evidence that it's not self-defense. Whereas now we've had this change in which it's up to you, the guy who acted in self-defense, to actually affirmatively bring that to the court, to the jury, argue for your instructions. If you're acting self-defense, you're probably planning on doing a lot of those things anyway, but still, we like most of the burden to be on the government wherever we can.
Yeah, and so you see, this might have some logistical changes to how folks defend these cases in Oklahoma. Ultimately, if you have self-defense facts, if the stuff is justified, it's going to get raised. And then at that point, yes, the burden's still on the government. They have to disprove self-defense beyond a reasonable doubt. So a little bit of a logistical change, but a huge expansion under when that defense would apply. All right.
So they do a couple other things in this 2818, adding occupied premises to the justification statute. So we talk a lot about.
It's an awesome definition.
It is an awesome definition. We should just read it. Do you have that?
We'll throw it up on screen.
Okay, yeah. So it is an awesome definition. So adding to it's your habitation, basically adding to this list of you get your justification here because this is your special place. We're sort of adding any place you're invited to be.
Yeah,
which is great.
The plain English definition is if you're inside of a structure and you have permission to be there, you're going to get this defense.
Right.
So everywhere's your castle.
Yeah. And then the other sort of nice thing here is, Oklahoma, right? They went to constitutional carry not that long ago. They're one of those states we were talking about. I don't know who worked on their constitutional carry bill. I know Richard and I worked on the one in Texas. And so the one in Texas is pretty
chef's kiss,
good.
except for what the Senate did.
Except for what the Senate did to us. The House version was perfection.
It was like 6 pages.
It was perfect. That was Richard's whole life. And then we got to go sit in the speaker's office and negotiate the floor amendments. It's awesome. It was the best thing I've ever done.
Well, if you're removing, all right, sidebar just for a moment. If you're removing infringements, this is what I don't like. This is one of my pet peeves.
We removed an entire chapter in infringements. We were good at it.
Well, all these other people, when they wanted to pass constitutional or permitless carry, they were just adding so much material. I saw some of these proposals and they were 50 pages, adding 30 pages of text to the law. Hey, guess what? If we're removing infringements, there's a real easy way to do that. You delete it. Yeah.
Struck whole chapters.
All right. Awesome. Sidebar away, but it's rearrange this stuff and delete.
Yeah, hell yeah. So anyway, but it looks to me, not being an Oklahoma lawyer, it looks to me like a lot of what happened is Oklahoma added, this law about constitutional carry without really going through in detail, figuring out where you might still be prosecuted or there might be some sort of problem if you did not have a license. Maybe those problems they didn't think would arise did end up arising over the course of these last several years. So we are also adding into this that you get the protections of this particular new law, whether or not you have a handgun license. It seems to me like you only add that in if there's been problems.
Yeah, and we did that in Texas. Think about all these extra protections that license holders got, like our employee parking lot bill.
Right.
We opened that up. Cities can't prohibit license holders from carrying in parks. Well, we got to move that too. So it's sometimes, and
but we do that on the front end.
Yeah, we do that on the front end. We cleaned this all up immediately. Yeah. So we had some forethought there. And so let's go on to this next one. This is 1095, and this is Emily's words, and I really, really like it. But this is reverse preemption, and so
it kind of is a reverse preemption.
But reverse preemption, when we talk about what is statutory preemption, that's when usually the state level government takes the authority away from cities, we call those municipalities, and counties. They take the authority away from them and say, we're going to regulate this issue uniformly across the state. Okay.
Generally a very good thing.
Yeah. And what you see a big push by these gun grabber groups is they hate statutory preemption. They want this place to be a legal minefield that's impossible to navigate so that it discourages folks from carrying. Okay. All right. Well,
Sneaky,
maybe
but
we want statutory preemption. Well, instead of saying not only what about a reverse preemption? Well, that's kind of what we're seeing here. And so it takes the authority away from, or it gives the authority to cities and counties to say, all right, the state has prohibited this, but if these cities and counties want to allow carry in these otherwise prohibited locations, then it's going to be okay.
Yeah, so basically they have their sensitive places list, as all states do. And I think it's good to chip away at these things, like, even if it's little by little. And they say, look, these are prohibited on the state level, right? Basically, the state says what's allowed and what's not allowed. However, if your city or your county wants to take some of these places off the list, we are giving you the ability to be more free. You can't be less free, but you can be more free should you choose to do so. Super. I love it.
Yeah,
I love it. I'm into it.
And then there's one more part we wanted to talk about in 1095. And this is, it would allow basically city councils to authorize their employees to carry in these otherwise prohibited locations.
Yeah,
So
not courtrooms.
not courtrooms.
Yeah, that's just,
Sure.
they can't do that. That's on the list. That's on the list of what they can't let people do if they want to be more free too, which is okay. Sure
Yeah.
enough.
How this work, you'd have your list of statutory prohibited places on the state level. City council votes, hey, guess what? We're going to allow our dog catchers to carry in this sensitive location. Just maybe that's the logistics for their city. It just happens to work out.
And city employees with licenses, I think. And
Yes.
now, of course, I don't have the bill in front of me, but yeah. So, I mean, it's pretty specific, but still it's like, yes, you should be allowed to open things up.
Yeah.
That's nice. Your city.
But
right?
these are sitting on the desk of the governor in the state of Oklahoma. The chances of him vetoing these are very low.
He's expressed that he's going to sign them. So that's a good, and they're little, I know. So I'm just, everybody, because we're going to get a lot of comments that are like, basically, any gun law is a travesty. Sure enough. But it is so, y'all, having worked in the legislature, and I actually think Texas, from what I understand, is one of the more functional legislatures in the country, which is insane because it is like an episode of The Real Housewives. But like, it's not easy. It's not easy to get stuff done, y'all. And so moving the ball forward incrementally, it's better than nothing.
Yes, it is.
Yeah.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please comment below, especially about that pocket veto issue. I'm really genuinely interested. So until next time, we're the Armed Attorneys.